People love simple stories. They want a hero and they want a villain. They want a good guy and they want to tear down the bad guy. They want a war criminal or they want a war hero. But somewhere in the middle of all of that is the boring stuff. Rule of law, no one wants to hear about that. Evidence, courtrooms, rules of engagement, all of that stuff can sound really boring, but it is critical when we're talking about an important story like Ben Robert Smith, arguably one of Australia's most decorated living soldiers, and the man currently at the centre of one of the biggest legal and also cultural blow-ups that this country has ever seen in years. So there have been a lot of claims that have been floating around, and that's what I wanted to address today. How can we spot the most common arguments that people use when it comes to this saga, and why some of them feel persuasive, but when it comes to a court of law and our legal system and the Australian law system, how it actually is treated and what's going to happen to them. Here comes the first claim, and that is the media is lying. And that claim normally is driven by something like journalists are profit driven, they're just trying to get clicks on stories, they hate the military, and therefore they're trying to stitch up someone in order to create this big story. Now, is it true that media companies have incentives in order to get these sensational stories out there in the public? Of course it's true, they're trying to make money, and so is literally everybody else that has a mortgage. It's also true that doctors want people to be sick so that they can treat them and make more money as well. But that's a story, I guess, for another video. But my issue with that is just because you can prove that somebody has a motive, it doesn't necessarily prove that it's false. And in this case, the court allegations, it wasn't just about what the media was saying. As you all know, these allegations were tested in court at length at a major defamation trial. And the judge at trial ultimately said that the allegations that were put forward by the media could be substantiated and were proven on the civil standard. And that's why the defamation case failed. And after that, there was an appeal, and the full court dismissed the appeal, saying that the standard of evidence that was provided was sufficient, and they supported the findings of the original court. And then when they tried to appeal it again to the High Court rejected it, saying that they're not going to hear the matter. So they normally do that if they review a matter and feel like there's insufficient grounds for an appeal there. So to just say that it's about the media companies and they've been incentivized to lie and all of these things are done to drive up sales and clicks, it's not enough, because it has gone through a substantial amount of the court system. Yes, not the criminal law system, the civil law system, and I understand it's a different standard. You don't need to harp on and go to war with me about that. You need to think about that. If they did lie, then it would have been tested in court, and if you're then saying that the court then got it wrong, then we've got a different argument on our case. Because if you're saying the court got it wrong or the judge got it wrong, then the Court of Appeal got it wrong, then the High Court got it wrong, and now you're starting to think that there's multiple levels of corruption within our society. And it's hard to argue with somebody that's going to be thinking like that, because they're just not going to accept any decision that they don't agree with. So the second big claim that I've seen is the reliability of the witnesses in the defamation case, and of course the same witnesses that are probably going to be in the criminal case, and that they have reasons to lie, that the witnesses were jealous, they're incompetent, that they're pissed off with the system and pissed off with Ben, and therefore we can't rely on their testimonies. And I've heard this a lot, and to me it is kind of really surprising to hear, because the people that are putting these claims forward, they're normally trying to support the ADF or the SAS, and they're trying to say that Ben couldn't have done those things. But in doing so, by using the argument of throwing away the witness statements, you're then saying that the credibility of all of these other ADF members and those SAS members that testified against Ben are not worth anything, and therefore you're kind of discrediting those people. So it does feel a little bit counter-secular if you're going to be taking that argument. Of course, when it comes down to witness testimonies, you're going to be looking at credibility, and in court, credibility isn't decided just about whether or not someone had a scuffle or a disagreement with somebody else. They're not just going to be looking at whether that person was jealous of Ben because Ben got a VC and they didn't. Courts are going to be looking at credibility because that's what judges do. They look at whether a witness is been providing reliable and consistent evidence, whether, sure, they might have a motive to lie, but that could be said about so many witnesses that do attend court. And just because somebody does have a motive to lie doesn't mean that they are going to lie. So if your claims are that, you know, those witnesses are rats and they were jealous, that is just not a rebuttal. And if anything, I find it insulting, because it might feel satisfying at the time when you're talking about this case. But you know, if you're trying to defend the Australian forces, if you're trying to defend a war hero, the Anzac legacy, and to do this, you have to step on other SAS soldiers who testified against Ben, then it feels really counterintuitive. Another thing I've heard people say is that witness testimonies can't be relied on because the soldiers are getting an indemnity from the prosecution and they're doing this to protect themselves. And yes, there's an element of truth to that, because they have been given indemnities, meaning that they've got protection from prosecution and they've received those indemnities in exchange for providing evidence about the case. And yes, this was done because their hands were dirty on a lot of occasions. They themselves admitted to some of the crimes that were committed, and they wouldn't have gone on these witness testimonies unless they received that indemnity, because they were involved in that serious conduct in those alleged unlawful killings. Indemnities are a very normal part of serious cases. They're not just used in war crimes, but they're also used in organized crime. They're used in corruption matters, because a lot of the times in those situations, the people that only knew what was going on are the people that are involved in it themselves. And that's why just because you have indemnities, it doesn't mean that somebody is lying. Yes, I can see why that it would be a motive to someone, because it can be seen as someone saving their own skin, and therefore it's unreliable and you can't rely upon it at all. But when the court considers these witness testimonies, again, it comes back to credibility, and the court's going to understand that they're going to have to treat that evidence with care. They're going to have to see it within the context of those indemnities. And don't for a second think that the defense isn't going to bring this up. They're going to come hard at those witnesses when they're cross-examining them, and that's the whole point of the trial. It's there to test the evidence. So I can guarantee what the defense is going to do in that stage is they're going to be asking them, you received an indemnity and that's why you've testified here. You're doing this to save your own skin. And they're going to attack the credibility of those witnesses. And all of that gets taken into account in a trial. A judge is going to look at that. The jury, potentially in these criminal proceedings, is going to look at that as well. So to use that as a smear campaign on the witnesses, I think it's insufficient, because the judge, the jury, everybody looks at the witness testimonies holistically, even in the context of having indemnities. Okay, so the next claim that I've seen online is that there were special rules of engagement at the time of the Ben Roberts-Smith alleged murders. And those rules of engagement allowed Ben Roberts-Smith to go out and kill people because we were in a war zone and all of the people that were there were then considered as combatants. So firstly, yes, rules of engagement are a rule. ROE 429 alpha as an example, that is a real rule. It's not fictional. It's not something that's been made up. And yes, there can be different rules of engagement depending on where people are in a war zone. But just because there are rules of engagement in place, it's not going to stop people from committing war crimes. And you've got to ask yourself the question, is there a limit then? If you're then going to rely on the rules of engagement, then is everything on the table? Can you claim that everybody was a combatant and do whatever you want with them? Okay, so let's hypothetically say that these rules of engagement were in place and everybody could be treated as a combatant. Let's just accept that. I want everybody here to imagine you're in the middle of a war zone and there's a rule of engagement in place saying that you can treat all people as combatants. In that hypothetical situation, would you still consider something to be a war crime if there was a combatant that was taken as a prisoner and put into handcuffs and somebody then shot that person whilst they're in handcuffs? Big questions here. Were they detained properly? Were they going to surrender? Had they already surrendered? Were they killed after the fight? And I want you to imagine this in the context of what would you expect and how would you want other combatants to be dealing with Australian soldiers if they were captured, if they had surrendered, if they were placed in handcuffs, and if they were then killed? How would you feel about that? Now, there's one more argument that I keep seeing pop up, and that is Ben was a war hero. He saved people's lives. He did the most extraordinary, brave things, and therefore these allegations just can't be true. Well, I think it's really understandable to have that approach, but that's not how humans work. It's not how war works. And history is full of people who did one extraordinary thing one day and later did a terrible thing. By looking at this case, some people would say that it's a disrespect to the people that served in Afghanistan. And in fact, I'd argue that it would be the opposite, and that if you actually respect the members of the ADF, then you don't treat unlawful killing as some kind of loyalty test and you treat it for what they are, and that is allegations at the moment. I think you can support the rule of law by insisting that you have evidence-based trials, a presumption of innocence, without turning it into an online blood sport and without pretending that we did have 5 years of court proceedings and that there might be some substance behind these allegations. Let's have the trial run and get to the bottom of this. Ben, in his recent statement as well, he said, I wish that this isn't going to happen, but I'm looking forward to the opportunity to clear my name. So he himself is saying that these circumstances, I don't wish them upon myself, but I'm hoping that through the process, I'm going to be found innocent. And of course, other people have different opinions, but it's important to keep a clear and open mind here and look at the evidence that's before the court. I hope you found this video useful. If you did get any benefit from it, please like and subscribe to the channel. It really means a lot to me, and I'll see you in the next one.